magistrate, benefit of set-off was not granted.
Rejected.
Rejected. In fact, it never was considered at that stage. Accused files the appeal merits. At the stage of appeal, the counsel for the accused submitted that he does not press the appeals on the merits of the matter. He would confine it to only seeking a relief to the extent of set-off being granted. But that came to be allowed in his favor. So the conviction remained, my lords, on merits. But he was granted the relief of set-off. Subsequently, my lords, which was an unwarranted action by the accused, they filed a revision petition. And these revisions, my lords, when they come to revision or appeal, when they are filed through the jail, my lords, they are mechanically filed always. It's a 1 or a 1.5 page appeal memo or a revision memo. It was filed. But the state has not come challenging the order of grant of set-off relief. State never came before this honorable court challenging the order of the appellate court. Now, in the revision filed again, the arguments that during the addressing of arguments by the counsel representing the petitioners, they also submitted that on the merits, they have no prayer to make. They do not want to pursue the revision petition. Only set-off could be granted. Set-off was already granted by the appellate court. Despite that, they confined that prayer again, which perhaps was not necessary. So at that stage, my lords, ideally the petitioner ought to have merely withdrawn the petition as such. And this honorable court has passed an order considering, my lords, the issue of body warrant, custody, in what case, under what circumstances it is.
The set-off granted by the appellate court?
The appellate court granted set-off in all the 9 cases.
Entitled for the benefit of 428 for the period undergone.
For the period undergone.
So that is
but eventually, but here what happens is first case they are in custody, my lords. Accused are in custody in the first case. From that day, there is no difficulty in the first case, in the first arrest, because on that day the custody counts. While in prison, an application is filed under 267 seeking the accused to be produced before the concerned magistrate on a body warrant because they are wanted in a second case. But second case upon production, essentially the magistrate has to decide whether he has to be remanded or not. The magistrate remands them back in the second case. He is remanded back in the second case. On that day, my lords, his custody in the second case essentially has to commence.
no, but now the appeal which is filed by the accused,
Please, my lords.
that came to be allowed partly.
Please, my lords.
However, the petitioners were found to be guilty
Please, my lords.
for the offense 454-380, and they were order of the trial court was confirmed.
Confirmed.
Sentence also confirmed.
Sentence confirmed, but they were granted the benefit of set-off.
Benefit of set-off was granted under 428.
Please, my lords.
Now, before this court in criminal revision petition, it is held that they are not entitled
Please, my
for
lords.
set-off.
Now, the state, my lords, did not file or state did not challenge the order in appeal. The order which has inured to the benefit of the accused was not challenged by the state. So to that extent, I would most humbly submit that perhaps, my lords, there was no jurisdiction that existed, my lords, to pass an order which had a result of, my lords, enhancing the sentence or the nature of sentence or the form of sentence. Though my lords has in detail discussed 428.
Correct. It is held, therefore, period of detention during trial and investigation undergone by accused herein would be entitled for the benefit of set off only in the case in which they have been arrested, for which this court has passed an order in criminal petition number so and so, granting the benefit of set off.
This they never came in criminal petition, it's only in revision is what they had come.
Huh?
They had come in revision, my lords, which is in review before this honorable court presently.
Yes.
So revision came to be filed.
Correct. I am reading the order of revision. Page 33 of my order.
Please, my lords. Therefore, the period of detention during trial and investigation undergone by the accused herein, they would be entitled for the benefit of set off only in the case in which they have been arrested, for which already this court has passed an order in criminal revision petition number 100115 of 2020 granting benefit of set off. I am of the considered opinion that the benefit sought by the petitioners for grant of set off under 420 of CRPC cannot be granted in the present case for the aforesaid reasons. It's 100115 could be the first case.
Correct.
First revision, my lords. But their custody, my lords, is in all the cases in which they were remanded.
Right. Whatever, right or wrong, this court has already passed an order
Please, my lord, there are, my lords,
confirming the earlier set off because of the period which they had already were arrested or for which they were in custody.
they were in custody in one first case.
Correct.
They continue to be in custody in the second case from the first date of the remand in the second case. They continue to be in custody in the third case from the first date of their
How
remand.
your revision is maintainable. You will have to challenge this order.
Lords, my submission is, my lords, there is this, if at all I would convince this honorable court on the fact, on the point of law, that this honorable court had no jurisdiction to, my lords, to alter a order which was beneficial to the accused and resulting in an enhancement. I was granted, my lords, set off in all the 9 cases.
No, that is not altered. That is retained.
But that remains altered. My lords, I get benefit only in the first case, my lords, criminal RP 100115. In that I get the benefit. In the subsequent cases, I don't get the benefit.
That must be dealt with already by this court that you cannot be entitled to, set off in 2 different criminal cases.
Please, but that's the reason that the appellate court had granted me that relief, my lord.
That is dealt with by me in para 23.
Please, but I was granted that the relief by the appellate court. State did not challenge it.
Even though state has not challenged, this court has not interfered with that.
But effectually, this order of my lords, results in effectively, my lords, that the benefit having been granted taken away from. Because I continue to be in prison even today.
Appearing for the state in this matter? Ati? Are you appearing in this matter?
In serial number 1, my lord, please, madam, I am not getting a proper hearing from that side, madam. I am not getting here.
ನೀವೆಲ್ಲ ಮುಗಿದ ಮೇಲೆ not hearing ಅಂದ್ರೆ ಏನು?
Yes, madam.
You should have said so at the beginning. I asked you as I came and sat in, Mr. Hatti. Are you able to hear the court?
No, my lord, that's why I am requesting.
You rectify your system, sir.
Please, madam, I have tried, madam, but sound is not coming.
Then you have to come here. If the sound is not coming, you have to rectify your system or you have to come here.
On again and again, on one revision, another revision cannot be maintainable as per section 397 of subclass 3.
This is not revision, he's trying to review.
No, this is a criminal revision petition, it is.
You have filed review or revision?
We have filed a review, my lords. However, the office has numbered it as a revision petition. Our review petition may kindly be seen, my lords.
So you should know what you have filed.
But we have filed a review itself, my lords. Memorandum of criminal review petition filed under section 362 read with 482. Review, my lords, there is no, the system doesn't not allow criminal review number to be accorded, given. So the office has numbered it as criminal revision petition. That was one of the objections which remained, my lords, right at the beginning.
How is your petition maintainable? You have to answer that first.
But it is on the ground that, my lords, firstly, this honorable court, my lords.
All right, Mr. Hatti, you're appearing in this matter, Allah.
In Dharwad matter, my lord, serial number first, my lord.
No,
First
we
to
are-
8, my lord.
1 to 9.
We are dealing
1
with
to
Dharwad
9.
matter only. So you go through and you tell me how this petition is maintainable.
It is not maintainable, my lord. On criminal revision, another criminal revision cannot be maintainable. My lord, kindly see that the section 397 subclass 3.
Sir, I'm aware of 397(3). Now he's trying to make it out like a review petition under 362. Even that would not be maintainable. So you please make your submissions. If you are not able to hear, either you come before the court or rectify your system and
Yes.
argue.
Next
Because
week,
this is
any date,
coming
my lord.
for
Next
the
week,
fourth or
any-
fifth time before me. And
Next
you
week,
also,
any date.
Mr.
I will, my lords.
Please
I'll
argue
give a
on-
compilation, my lords. I will have a challenge here, especially on in each
have
case,
to-
what
you-
has been.
You have to first read my judgment. The issue which you are now canvassing has already been answered in para 23 and the operative portion. The set off which was granted is not disturbed by the criminal appeal court. Set off which is granted is maintained. This court with regard to further set off which is sought for the same case is negatived in para 23.
I will have a look. But
Please
however,
read that.
I've
You-
had a look.
Mr. Hatti, you also read that. That
Please.
is first aspect. Second aspect is to how whether this review is maintainable. And if that is a revision, how revision is maintainable. Second revision is not maintainable.
Review is
370.
what I would submit. That's the reason I was.
As
sought
per
for
397, my lord,
recall
it is
of the
not
order.
maintainable.
My prayer is for
Recall also
recall.
will not be maintainable. How a recall can be done? when-
There are, I'm armed with sufficient judgments, my lords. Even the Honorable Supreme Court says when there are orders passed under certain circumstances, the 362 bar cannot apply. There can, once it is, if at all it was without jurisdiction, or when the fraud has been played on the court. For example, my lords, I have submitted earlier, my lords, in 2 cases when the incident is said to have taken place, I was in prison.
Yeah, that's
No
a-
doubt,
that's
as my
wrong.
lords have earlier observed, it was a defense available to me, yes. But my lords, for the authorities to prosecute me in a case for statistical reasons, that I
Again,
have
you are
committed,
touching upon the merits again.
on that issue,
If you are touching a single piece of evidence.
I don't intend, I don't.
Evidence matter on merits, your revision 362 is not maintained.
I do totally agree.
Very simple. When I pass an order, I become functus officio. You have to challenge it. If
On
it
the
is-
point of
if it
law
is an
also-
alteration of any clerical arithmetical error apparent on the face of the record, then you can maintain. Otherwise not.
Please, I will convince on that.
All right. Counsel for petition.
LCRs could kindly be called for, my lords.
What is the requirement?
Most requirement is, while the first produced before the court, what was the order and on what application filed by the police? Was it on an application under 167? If yes, my custody commences on that demand.
Again, that will be touching upon the merits.
So on the point of law,
You have to challenge it by way of appeal further. For
my
the next
relief
court.
would be only in this before the Honorable Supreme Court. These are indeed,
You are represented by a counsel on record. You are not by a state,
it was all through, my lords, through legal aid, my lords, all through. At
even
the
by the
stage of-
revision.
Even in revision through legal aid, my lords. all through.
ಏನ್ ಮಾಡೋದು ನೀವು appear ಆಗಿಲ್ಲ ಅಂದ್ರೆ that is only last order.
Appear ಆಗಿದ್ರು, but no instructions at all. They were
What
not
to
in a
do?
position.
Accused will do that. After taking suspension of sentence, he will not come. That's what I'm seeing now every day. We are appointing amicus because we can't dismiss. That's another problem.
We have been in custody all through.
Criminal revision or in the final hearing.
In
This
appeal.
court cannot dismiss for default. What to do? Then the amicus will have to be appointed. Hear the matter on merits and dispose it. Please go through. I don't think records.
LCRs could kindly be called for.